instructional video will focus on public notice requirements for all applications filed to DNR for a construction permit under Construction in a Floodway, Lakes Preservation Act, Lowering of the 10-Acre Lake Act, which is the Ditch Act, Navigable Waterways Act, Sand and Gravel Permits Act, and Channels Act. This video will review the statute and rule that regulates public notice, the purpose of public notice, who is responsible to provide public notice, the state forms to use for public notice, methods of serving public notice, public hearing requirements, and other helpful instructions. The statute and rule that applies to public notice are the procedures governing certain licenses statute IC 14-4 and the procedures and delegations rules 312 IAC 2-3. Additionally, in 2005, a DNR administrative law judge ruled that the practice of providing public notice to adjacent property landowners prior to submitting a permit application to the Department of Natural Resources is in conflict with 312 IAC 2-3-3. Therefore, public notice must be provided to the adjacent landowners after the application is submitted to the Division of Water. If the public notice is submitted with an effective public notice date prior to the application receive date, it will need to be appropriately served again to the adjacent landowners. You can find the statute and rule on our website at www.in.gov/DNR/2453.htm. The purpose of public notice is to notify adjacent property owners of proposed projects and allow them to have the opportunity to comment on the pending construction projects. This provides the public with a mechanism to be informed of construction projects, submit written comments, or to have input on the project, make their concerns, objections known to the department, submit a petition for a public hearing, and request to be notified of the department's action. The 30-day public notice period starts with the date that public notice was received by the adjacent property owners. This means the department cannot take an action on a permit application until 30 days have passed after the adjacent property owners received the last public notice. The applicant or their agent is responsible to serve a notice to the adjacent property owners. In addition, if the applicant is not the owner of the property where the construction is proposed, the applicant or their agent is responsible to provide notice to the landowners where the construction will occur. Using public notice, State Form 50354, the applicant or their agent is required to notify at least one of the owners of each parcel of property that adjoins the construction parcel and the owner of the tract of land where the construction is to be proposed, if it is owned by someone other than the applicant. The Department of Natural Resources is also responsible to provide public notice to the general public. The DNR 30-day public notice is posted on the Division of Water's webpage on a weekly basis. An adjacent property owner is one whose property shares a common border or point with the tract of land where the proposed construction will take place and is within a quarter mile of the construction limits. This includes property that would share a common border or point if not for a separation caused by a right-of-way, easement, or railroad. Roadways and waterways are considered right-of-ways. This does not mean that everyone within a quarter mile must be provided public notice. It means that only those properties that share a common border or point within a quarter mile of the proposed construction limits need to be provided public notice. Let's look at some examples of adjacent property owners. In this example, a bridge is being replaced within a county highway easement. The yellow lines indicate property boundaries. The map shows that adjacent landowners B, C, D, and E share a common border or point with the construction limits of the bridge replacement and need to be notified. Landowners A and F do not share a common border or point with the construction limits of the bridge replacement and do not need to be notified. This example shows that the proposed project is on a small tract of land, noted here as parcel L. The yellow lines indicate property boundaries. A blue hatched circle was drawn around the construction limits to show the quarter-mile limits. We are only including those adjacent property owners with a common point or border and are within the 1/4 mile buffer. The map shows that adjacent landowners B, E, G, K, and L, if not the same as the applicant, share a common border or point with the construction limits of the proposed project and need to be notified. Notice that although landowners A, C, D, F, H, I, and J are within a 1/4 mile of the construction limits, they do not share a common border or point with the construction limits of the proposed project and do not need to be notified. This example shows that the proposed project is on a large tract of land, noted here as parcel I. The yellow lines indicate property boundaries. The blue hatched circle was drawn around the construction limits to show the 1/4 mile limits. We are only including those adjacent property owners with a common border or point and that are within the 1/4 mile buffer. The map shows that adjacent landowners B, C, E, F, G, H, and I, if not the same as the applicant, share a common border or point with the construction limits of the proposed project. However, notice that all of them are outside of the 1/4 mile buffer. Adjacent landowners A and D do not share a common border or point. In this example, the only one that would be notified is adjacent property owner I, but only if it is owned by someone other than the applicant. There are 2 state forms that are required to be used for public notice. The first is State Form 50354 that is used to provide public notice to the adjacent property owners, and the second is State Form 52086, referred to as the adjacent property owners listing, that is used to list the adjacent landowners' names and addresses and the date that public notice was provided. The adjacent property landowners listing is submitted to the Division of Water, whereas State Form 50354 is given or mailed to the adjacent property owners. Let's look at these 2 forms in detail. State Form 50354 is sent or handed to the adjacent property owners. This form must contain the date, the applicant's name, the applicant's address and telephone number, the agent's name, the agent's address and telephone number, the stream or lake name, a project description and construction site location, the relevant statute or rule, the name of the person questions should be directed to, and public hearing information. Continuing, you would also need the department's jurisdiction under the Flood Control Act or the Lakes Preservation Act, notice of public hearing or notice of initial determination information, and the request administrative review information. State Form 52086, the adjacent property owners listing, is sent to the Division of Water and must contain the name and address of the adjacent property owners, application number, signature, date, method of service, and date public notice was provided. There are 3 methods of service for public notice. They are personal service, first-class mail, and certified mail. Personal service indicates face-to-face contact. If personal service is the method used to provide public notice to an adjacent landowner, the date that the hand delivery occurred on should be indicated on the State Form 52086, Adjacent Property Owners Listing, as the date of delivery. If you provide public notice by first-class mail, the name and address of the property owner, date that the first-class mail was provided on, and a copy of PS Form 3817 as proof of mailing will need to be submitted to the department as proof of public notice along with State Form 52086, the adjacent property owner's listing. The person who signs the form is affirming that 21 days have passed without the mailing being returned. The post office will stamp a dated postmark on the PS Form 3817 indicating delivery of the public notice. Additionally, the effective date of the public notice is the date of mailing. Here is an example of the PS Form 3817 that must be submitted to the department. The blue arrow indicates where the post office will place a dated postmark. If public notice is provided by certified mail, the name and address of the property owner, date that the certified mail was received will need to be entered on the State Form 52086, the adjacent property owner's listing. Submit a copy of the form and a copy of the PS Form 3811, the green card, to the department as proof of mailing. Additionally, the effective date of the public notice is the last date of receipt if more than one certified mailing was sent out. Here's an example of PS Form 3811. Additionally, a certified mail receipt is not acceptable as proof of public notice. If the mailing for first-class mail or certified mail is returned as undeliverable, no forwarding address or no such address, another attempt to notify the property owner must be tried. However, if the mailing for first-class mail or certified mail is returned as refused or unclaimed, submit a copy to the department of the envelope showing that the mailing was stamped refused or unclaimed and no further action is required for that adjacent property owner. As a last resort, the public notice can be published in a local newspaper within the county where the proposed construction activity is going to take place for 1 day. However, either personal, first class, or certified mail must be attempted before legal publication can be used as a means of public notice. There are no exceptions to this rule. A copy of the publisher's affidavit and a copy of the notice that was placed in the newspaper must be submitted to the department as proof of public notice along with State Form 52086, listing of adjacent landowners. The effective date is the day the notice is published in the newspaper. Additionally, a newspaper template is available through our office. Please call 1-317-232-4160 for a copy of the newspaper template. If there are no adjacent property owners to provide public notice to, State Form 52086, the adjacent property owners form, will need to be submitted to the department indicating that there are no adjacent property owners, along with proof that the applicant owns all of the property around the project within a quarter mile, a deed, legal description, etc. Public notice provides an opportunity for landowners to petition the department for a public hearing to voice their concerns or comments regarding the proposed construction. The requirements for a petition must include the application number, project location or applicant's name in order to correctly identify the construction project, and the permit application number if known. The petition must include a minimum of 25 names, addresses, and signatures that are legible. The petitioners must be at least 18 years old and live in the county or own real property within 1 mile of the proposed project site. Once the department receives a petition for a public hearing, we are responsible to schedule it in the county where the project is located, preferably in the county seat. The room must be ADA compliant, free of charge, and large enough for all of the interested parties. Additionally, by rule, the notice of the hearing must be received by the petitioners at least 18 days in advance of the hearing. A representative from the DNR will arrive at the scheduled location of the public hearing to conduct the public hearing as a hearing officer and record the comments and concerns of those in attendance. A time period will also be given to those who could not attend the public hearing in order for them to submit their comments and concerns in writing to the department. Although the law allows a 30-day public notice period, a public hearing can be requested at any time before the permit application is acted on. After the permit application has been acted on, the decision can be appealed. The information for appealing a decision is listed on the permit approval or denial. All of the adjacent property owners and those who are listed on the petition will receive a copy of the action. In conclusion, we have covered the statute and rule that applies to public notice, IC 14-11-4 and 312 IAC 2-3. The purpose of public notice, who is responsible to provide public notice, examples of adjacent property owners, form requirements, methods of service, legal publication requirements, and public hearing requirements. If you need additional information regarding public notice, please refer to the Permit Application Assistance Manual, Public Notice Requirements and Instructions, and examples of adjacent property owners on our website at www.in.gov/DNR/2455.htm. The department can also be contacted at 1-317-232-4160 or toll free at 1-877-928-3755. Additionally, we can be reached by email at water_inquiry@dnr.in.gov for answers to specific questions regarding public notice. Thank you.